Thank you all for coming. It's really great to see you all here. Many of you I've spoken to. Others I've corresponded by email, but it's really great to meet you all in person and for you all to be here. I mean, the reason that we've been reporting on condo issues is really, there are two main reasons. One, so many of us live in condominiums here, and it's, Terry referred to this as the condo population is the second largest island. If you put everybody together, it's more than all of the neighbor islands, and almost more than all of the neighbor islands combined, the population of people living in condominiums. So it's huge. Then there are also, as you know, these are private governments. The associations are quasi governments, and they have a lot of influence over your lives. So we really are focusing on that, and we don't cover them the way we cover other governments. It's just a different, it's just impossible with over 1,000 of these associations. So this is why we're focusing on it. And, today we're really going to explore a basic question or a proposition, and that is whether the current condominium laws and rules adequately protect the owners. So we're going to discuss this with the panel. We have many variations on that theme to discuss, but that's the overarching question. And I think you'll be surprised to find out how nuanced and kind of complicated the answers are and the views are of our panelists. Also, as Ben said, we want to hear what's on your mind, so please fill out cards. We'll answer as many questions as possible. We are going to try to keep this very tight and organized so that people we have a chance to respond to as many questions as possible. So if it seems like we're cutting people off, I apologize ahead of time, but it's really for the sake of getting a lot of questions answered as much as possible. So with that introduction out of the way, I'd really like to introduce our panel. I think you know many of these people. They're constantly in Civil Beat, or often in Civil Beat and elsewhere in the media. We have Jane Sugimura. She's president of the Hawaii Council of Associations of Apartment Owners. She's also a senior associate in the law firm of Clay, Iwamura, Police, and Nervell. She's concentrated her practice on commercial litigation and is regularly practicing collection and landlord-tenant law in the Hawaii District Courts for over 40 years. She's been a member of the District Court Rules and Forms Committee since 1990. Thank you, Jane. Thank you for coming. Thank you. Yeah. We also have Richard Emery. Richard is principal broker of Hawaii First Realty and vice president of Hawaii Affairs for the condo management company Associa. Richard has more than 32 years experience in association management and holds the Reserve Specialist designation from the Community Associations Institute, a trade group for associations. He's also a member of the Hawaii Real Estate He's Hawaii Real Estate Commissioner, overseeing regulation of condo projects, association, and agents, and a member of the National Association of Parliamentarians. Thank you, Richard, for coming. It's really great to have you here. Many of you also know Lila, of course, Lila Mower. She began her legislative advocacy efforts in 2014. As a condo owner, she was subjected to malfeasance in condo governance, and she advocated for honest and fair elections, better education for owners, to prevent retaliation against owners, and to mandate licensure for management to ensure accountability. Her most important victory was helping pass 2018's Act 195, which eliminated the old paradigm of pay first, dispute later. And as you know, and she was president of the Kokua Council from 2020 until last month. And she stepped down, and now she is Kokua Council's president emerita. And thank you, Lila. And then finally, we have Terry Revere. He's the owner of Revere and Associates. He's worked on thousands of cases in 20 plus years of practice. These include cases involving personal injury, insurance, aviation, construction, business litigation, and class actions. He specializes in condominium and community association law, representing both associations and homeowners, and he's practiced before all the courts in Hawaii and has been called in to consult on several cases in several states and in the United Kingdom. And one of Terry's most significant cases was the condominium landmark case, Molokai, known as the Molokai case. So thank you, Terry, for being here. And I want to start off with just a question. We'll have questions coming in from you guys, but I want to start off with a question that I know a lot of people have asked, and it involves attorney's fees and debt collections. Hawaii's debt collection I'm sorry, I jumped ahead. So for the question of whether current laws and rules adequately protect condo owners, we're going to let the panelists discuss this, to what extent they do and don't. And we'll start off with Terry and Lila, and they'll have a few minutes to discuss it, and then we'll move on through the panel. So go ahead, Terry. Do they adequately protect people?
The short answer is no. The longer answer, because I'm a lawyer, so we talk a lot, is as Stewart just mentioned, the idea and what you will hear from the industry is, it should be self-governed, lawyers shouldn't be involved, the government shouldn't be involved, because it's a democracy. But quite often, for example, in a real democracy, you can look at the congressional record or look what the city council voted and know, hey, my congressman voted in favor of X or against it. I'm going to vote for or against him or her. There's a massive problem with, for example, executive session, which is supposed to be very limited. It's supposed to tell the owners, this is why we're going to executive session, etc. Quite often that gets abused. The open session is there for show and to check off boxes, and executive sessions where everything actually gets discussed. And there's no equivalent of a congressional record of what did the board vote on, what did they do. No one ever knows. In the case that Stewart mentioned, that Molokai case, for example, a board member, I asked, hey, did you vote to sue my client? And she said, no. I didn't have any basis to dispute it, so I didn't name her in the lawsuit. And then 2 years later, the other board member said, she lied to you. She voted right along with the rest of us, but there's no record to prove it or disprove it. So that's just one example of something that very much needs reform, in my view.
Yeah. So, thank you, Terry. So what do you think? Jane, Richard, what do you think about this? I know your answer is a bit nuanced, but generally, the rules actually protect people adequately, or what?
Well, my name is Richard Emery, and it wasn't listed. My primary focus today is the consultant, where I actually represent homeowners as well as boards on various disputes, and have done about 40 in the last 2 years. So I think I have a pretty good understanding of what's going on in the condo world. And I would tell you right now, the condo world is not perfect, but to say it's imperfect wouldn't be correct. I'm going to briefly take you back to the year 2008, where our legislature adopted a law basically setting up the Office of Administrative Hearings for condo matters, very similar to the ombudsman program that was presented last year. And the law was adopted in 2008 with a sunset date, because there was a lot of testimony against it back then, with a sunset date, meaning it automatically expires in 2011. It was extended to about 2013, but at the end, the legislature allowed that to expire because it had very poor results, which if we have time, I'll go into why it failed. We've tried this setting up another governmental agency previously, and it didn't work. I believe within the existing framework of the existing laws, with modifications to the obligations of the Real Estate Commission, Regulated Industry Complaint Office, adjusting some of the format within the existing rules we have today, that the system can be made better for both homeowners and boards alike.
What do you think, Jane?
Well, in response to that, there's always room for change. Oh, there's always room for change. And I just want to share with this group that the reason that I got involved, in the condo issues many, many years ago was leasehold reform. And at that time, I was a Bishop Estate lessee, as were many thousands of people in the state. And we worked very hard, and especially with Kamehameha schools, to change that so that now, and it took years, and we had hard fights back in the late 80s and 90s in the legislature to change the law so that lessees could acquire their fee. And it was a long, hard-fought battle, and that's how I got involved. And I would encourage people that not to be complacent and to settle for the status quo, that you have to be involved in your community. You have to participate. You have to talk to people. You have to try to do what's best for the community, and do what you can to effect change. And in my case, it meant going to the legislature and basically going toe-to-toe with Kamehameha schools. And it took years. But, in the end, what we got was a settlement. We talked Kamehameha schools into saying, hey, if you sold the leasehold, think of all the money you would make. Think of all the money you would make. Years ago, they were land rich, cash poor. Now, they have so much money because they sold their fees. And what it did too, it allowed thousands of lessees to become fee owners.
Yeah, amazing. And that case went all the way to the U.S. Supreme Court.
Yes.
Yeah.
And it took an army of people. It took an army of people. And I know back in the day, I would go and talk to different condominium groups and say, join us.
Yes.
Join us, because unless I have the numbers, the legislature won't listen to us.
Yeah.
And we got the numbers. We went to the legislature,
Yeah.
and like I said, it took years.
Yes.
And we persuaded Cam School that it was in their best interest to sell the fee.
Okay, great. Well, let's move on. Lila, what do you think? You get the final word here, Lila. What do you think? Adequately protect people or not?
Not at all. Touching upon what Richard brought up about 2008's enactment of condo court, one of the reasons it's failed, and a very important reason it failed, is because DCCA depended on managing agents, the property managers, to let the associations know that this alternative dispute method of resolution was available. Well, guess what? Why would the managing agents want us to know? So the information was not dispersed, and so it failed. If people don't know about it, how can they access it? Now, my colleagues and I are supporting an ombudsman. Call it whatever you want to do. Call it a condo owner's advocate. We need an alternative method of dispute resolution. I do a study, which I disperse to the legislators. This is 33 years of Hawaii Condominium Bulletin mediation case summaries. And I produce a chart, I don't have it in front of me here, showing what the results of those mediation cases are. So first of all, interestingly, 80% of the cases were filed by owners against their associations and their boards. 99% of those were disputes about violations of the governing documents or adherence or compliance with 514B. Of the mediated cases that were subsidized by the Condo Education Trust Fund, 3/5 of them were withdrawn, unresolved, unmediated. 3/5 is not a success if those things did not happen. 514B, Section 146G, disincentivizes resolution. Do you know that if we don't settle in mediation within 60 days, the association can claim all the fees, all the disputed amounts, so forth and so on? Okay, why does the association have carte blanche on that? That's not protective of owners.
Okay. Yep. I want to get back to that question and pose it to everybody. But,
right.
and the reason I want to do this, to start off with a few questions I have, and then we'll move to questions from the audience, is that we received numerous questions from individual people who took the time to write to us and say, I have this specific problem. Here are the facts. Here's some documentation. Can you answer this? And wanted us to pose it to the panel. And we just don't have time for that here. It's a complicated analysis that, again, we just don't have time to do. But it got me thinking, like, it sounds like a lot of people really have these kinds of questions and do want some kind of alternative dispute resolution or something, a referee, something besides mediation. And I knew Lila had talked about this a lot, so I want to pose it to the panel. What do you think about something like that? We get the questions. I could be giving you the questions and ask you to sort through it. People want to know. A lot of the people in this room have disputes. They want us to answer. What is the solution? Isn't there a need for something else or a room for something else? And, what's wrong with an ombudsman? Could there be a nonprofit legal aid society for condo owners? Some other solution? What do you think, Jane?
I don't think that an ombudsman. I'm sorry. I don't think that the ombudsman is the answer. We had a situation where we had condo court. I think Richard mentioned it, and I don't remember the dates, but it basically was a situation where if you had a dispute, you could bring that to the attention. Who was it that was the condo court?
Who is the hearing officer?
Yeah.
Rod Riley.
Right. There was a hearing officer, and you could actually go, and he would listen to both sides, and you would get an answer. And I remember that it was it had a sunset, and we fought the sunset because I think the original term was 2 years, and we said 2 years is not long enough for a program. You got to extend it. And so we got it extended at the legislature. And even with the extension, it just didn't seem to, I don't know whether people didn't know about it, and they didn't, come forward, with the disputes.
Yeah.
But,
what do you think, Richard? Room for something or not?
Well, I'm not here to tell you that the condo world is perfect. Most of my casework is representing condo owners on disputes with associations. But what you have to remember when you move into an association, as was said by one of our courts, is that you give up a certain right. You have to all give up certain rights to be able to live harmoniously together. And so there's certain rights you have to give up with respect to this. So over time, what the legislature has done is they set up this, what we call facilitative mediation, that was later added evaluative mediation, which is much more prominent and used more often. And then we have this condominium arbitration, which is a non-binding form of arbitration. All because the courts have been determined, because of the ruling, these are private organizations, and the courts can't really impair the contract that exists in the governing documents between the owners and the association. And so what has to be done is to find methodologies that will work together to balance the playing field and the table for both sides. And most of my work that I do privately is on behalf of owners.
Sorry, we need to move it on for about a minute each to give people a chance. Terry, Terry, go ahead. We'll get back to it. Go ahead, Terry.
So there's been, I'm aware of, I don't hang out at the legislature because I'm too busy being in courts, that branch of government. But as I understand, there's been an ombudsman proposal. There's other people that are talking about a quick and dirty evaluation, sort of almost like an expedited version of what used to be the condo court. I'm kind of a big fan of letting people be adults, because maybe going to an ombudsman to say, can you just tell that property manager to give me these documents, rather than hiring a lawyer to tell them the same thing. That is a possibility. It might work. But what I think people need to recognize is that when you have an ombudsman, it is not going to look like me. And it is going to be someone that's going to get appointed, is going to be a state worker, and is going to be exposed to industry insiders all the time. So if you think you're going to be getting a firebrand that is going to make your problems go away, I'm not sure that's how it's going to pan out at the end of the day. That being said, the more different avenues there are to off-track things from the litigation system, mediation, evaluative mediation, a condo court again, whatever, ombudsman, anything that helps off-ramp things from the legal system can save everybody a lot of time and grief, and let people make their own decisions about where they want to go.
Lila, what do you think?
Thank you. Whether it's condo court, mediation, arbitration, litigation, associations and their boards are represented by the association's attorneys, and sometimes by the association's insurance attorneys supplementing those attorneys. Well, that means that in order for an owner to have justice, the owner is compelled to find legal assistance. And in my opinion, justice that is available to only those who can afford it is not justice. And what we're looking for is justice and fairness. I don't care what it's called, ombudsman, advocate, whatever it's called, we need a fair playing field.
Yeah, if I can ask you, though, to address some of the other questions that they came up to this just a moment ago, and they often come up. These are considered private, self-governing entities. What about it? Just have the government get out of the way and let people settle it. What's wrong with that idea? Lila, go, and then we'll come back this way. Yeah.
Okay, I think originally when condos were new, and I think that was, a working idea, that it was self-governance was fine. But as our condo governance became more complicated, I don't think it's possible. Quite frankly, in this day and time, self-governance is a myth, it's an illusion. It's a way for the trade industry to prevent condo owners from seeking owner protective measures.
Yep. Terry, what do you think?
Yeah, I think they tried that once, and it was like these little British schoolboys, and they got shipwrecked on an island, and then they self-governed. And it was the Lord of the Flies. So that is often, and you can look, and I say all the time, like a lot of my job, I feel like I'm stepping into a long Stanford prison experiment. Are people that you're called guard, you're called board member, and I've seen otherwise normal people that I've helped lead the rebellion to get rid of bad guys, and I install my people, and some of them turn out to be just as bad.
Yeah, Richard, what do you think? That was one of your points.
Well, I think certainly there are issues and where owners have a right to be heard in discussions, but you do give up certain rights when you live in a condominium. You've agreed by your governing documents, and the legislature doesn't have the full authority to undo what's been a contractual relationship or impair private contracts. So we have to look at what we have to deal with and how we can make it better. I'm not a fan of the ombudsman issue because I think it's a repeat of what we've done earlier. But I do think there are changes that can be made in the existing law to expedite and improve the communication and solve the problems of an association without going to the extreme of creating a whole new government that all of you condo owners are going to pay for one way or the other.
Yeah. Jane, what do you think?
I sit on the District Court Rules and Reforms Committee. I've been there for over 30 years. And I sit on some circuit court committees. And it's funny because the judges seem to know my connection with condominiums. And I've had several judges say to me, why can't you people get along? Why can't you people get along? They hate condo disputes. Judges, I don't know of one judge, when they see something coming through their docket and it's a condo dispute, it's like a pox on both houses, the owners and the associations, and what the judges will do, they'll send you to mediation.
Yeah,
they don't want to handle it.
Well, sure. So, but let me ask you something else you brought up. You mentioned people not being involved, not being part of the association, not going to meetings, all of this stuff. What we often hear about is that, we hear that residents are complacent. But then residents often say, wait a minute, if the boards are a bad board, they can do all kinds of things to prevent us from actually voting them out. And they'll withhold documents. They can control the town square communication system. They do all of these things to make it hard for the incumbents to be removed. What about that? Is the current election system and the way things are set up fair enough that people can be voted out as easily as they should be? And if not, what could be changed?
Do I?
Yeah, Jane, you start. Yeah.
People have to organize. And I can remember when I was an outsider and I had to, talk to my owners and organize them and go to the board with petitions and names and say, this is what we want, this is what we're upset about, and you need to listen. And what people have to understand that, boards only meet like once a month. Boards set policy and, they policy for the association. The management then carries out those policies and does the,
Sure.
implementation.
Sure.
The board is not involved in the day-to-day operation of the condominiums. They never are. They're not supposed to be.
What do you think, Rich? I'm sorry to interrupt, but Richard.
And if they are, they're doing something wrong.
Right.
They're not supposed to be involved in the day-to-day operation.
Richard, what do you think? Easy to throw people out or not?
I think we see it every year where boards and owners organize to have their board removed or certain members removed, and it's working. But the reality of it is there's always two sides to a story, and I would just say to you from my experience, I don't like us saying bad boards and everybody's bad and they have these hidden agendas. They're just owners like everybody else trying to do the best they can to manage their property. To say there aren't boards that go across the line, certainly that's true, but to cast the whole industry in this light of negativism isn't fair. There's...
Terry, what do you think? I mean,
The elections are not free. The elections are not fair. We're not at North Korea levels. We're not at Russian levels, but somewhere between Russia and the Western world. And there are reasons for that. For example, the drumbeat you'll hear is it's self-governance, blah, blah, blah. Well, that implies certain things like everyone will have the same access to the voters. Because 514A, which is the predecessor statute, was written before email, what it says is, oh, well, if you want an owner's list, we will give you their physical addresses in Tokyo and Kansas City or New Jersey or Mililani and the condos on Maui or whatever. So you get that physical address to lobby and spend your money printing things up and mailing it out. The board, in the meantime, has everybody's emails and shoots it out and can lobby them. A very, very simple reform. Everybody gets access to the emails. The complaint is, oh, well, some people don't like emails. You don't like my email? Block me. But everyone should have access. The ballots for ballot measures are not confidential. The board secretary and the management company look at that. I've just had 2 cases in the last 6 months where the insiders see who voted, see how they voted, try to lobby people to change their votes, or at best target who didn't vote. That's not an advantage the opponents have. Yeah. So it is very difficult for non-board members to get elections. And when you say self-governance, it's got to be fair, and it's not.
What do you think, Lila? What do you think? You're nodding your head.
Okay, so first of all, proxies, that's really a big problem. I think 80% of the emails that I get from condo owners are about proxy problems. Just want you to know that Florida, Texas, Illinois, and Arizona prohibit election of directors by proxy. Okay? California, they have a provision that the bylaws may be amended to prohibit proxy voting. In Hawaii, a lot of owners don't know this, we can vote by mail, by ballot. But the managing agents don't tell us that. They follow the proxy voting process. And so that's what we think is necessary. In Hawaii, we had public elections in 20 and 2022. 95% of those who voted by mail-in ballot. A mail-in ballot will replace a proxy. Okay, that's important to know. And then whenever I bring up getting rid of proxies, I hear the opposition saying, well, we need a quorum. I just want to remind the opposition that back in 2015, they voted to reduce quorums. That was Senate Bill 826 and House Bill 275.
What do you think, Jane? I know you mentioned things aren't perfect. Did your group take a position on these bills that Lila's talking about?
Well, this year?
Were those bills this year, Lila?
The ones I just mentioned were.
Yeah. This year, did you take a position? Have you taken a position in the
I
past?
didn't take any position on any bills this year.
Okay. Richard?
Well, as you all know, we're all governed by Robert's Rules of Order. And there's a procedure and a process in the bylaws that talks about the order of business and how things are done. There truly are no candidates until the meeting when someone is nominated from the floor. You may have interested people to run for the board, but there are no candidates, and there's an election process, which includes people's right to vote by proxy. And to me, a proxy is an individual right. There's nothing in the law that tells you you have to give a proxy or not give a proxy or who to give it to. It gives the person not there and present their sole choice to pick who they want to represent them.
Okay. Well, it sounds like there is an impasse here, but here's something that maybe people can agree on. Again, given your statements that things aren't perfect and might need to be changed, Jane and Richard. One of the things we hear about a lot is that, debt collectors and other other sorts of debt collectors can hire lawyers, but only pay. The lawyers can only receive or charge the debtor 25% of the amount of the debt as a legal fee. In condominium, I'm sorry. Yeah. In condominiums, there's no limit, and we have heard cases. I've written about cases where people are being charged thousands of dollars in legal fees for fines that are far less than the amount of the legal fees that are being charged. Should there be a similar restriction on lawyers?
Well, I can answer that. Number one,
no, we can go.
the 25% is for a judgment. I mean, it's by statute. Okay, the 25% is, but the attorney's fees by statute say reasonable. And so it's always subject to a judge's discretion.
Right.
In other words, if an attorney, and the attorney has to submit billing records to the court. And how many hours did you spend? What was the complexity of the issue? How many letters were written? And how many hours were spent?
Right.
And then the judge determines what the attorney's fees are.
Yeah. Terry, go ahead. I'd like to hear about that.
The best thing about starting one's own law firm is that you don't have to worry about your law partners anymore. So this is 100% an absolute, unadulterated, lobbied for scam. It is a scam. It is a scam. It is a scam. And the reason why we know it's a scam is if you are a butcher or a baker or a candlestick maker and someone owes you money, let's say they owe you $1,000, what the general statute that applies to everybody in this state on a breach of contract type claim is, yes, you can sue and you can get 25% of the amount in controversy. So if you got $1,000 debt, you go to district court, you get a judgment, you get $1,000, plus you get $250 in your attorney's fees. Everybody else in society pretty much lives with that except for one group, condo lawyers. Condo lawyers lobby to say, oh no, we can't possibly do that because then the homeowners will suffer when we charge them so much. Well, that is bunk. There's lots of collection attorneys out there for banks and small businesses. You don't have to hire a condo lawyer to do your collections work. They can run it efficiency like everyone else. So that same 25% cap ought to apply to condominiums like it applies to everybody else, for sure.
What do you think, Richard?
Well, there's different types of legal fees. There's collections, like your non-payment of maintenance fees or some amount that's owed in a fine, which the 25% cap applies. Now, because I do expert work, let me just give you the quick example of an owner who decided to take their family room and make it into a second kitchen in violation of the building code, and decided they were going to do short-term vacation rentals in contradiction to the governing documents of the association, and through that process had their short-term tenants use all of the guest parking for its tenants, causing all these complaints by the other owners. So should that association and enforcement of its documents be limited to the other owners shouldn't have to pay the legal fees on this. This is a person who intentionally violated the governing documents and violated the county building code, violated everything. So those costs should be borne by the owner who caused the problem.
Yeah, what do you think? No, that's a good point. Yeah, what do you think? What do you think, Lila? What about that idea that, or Terry, if you want to weigh in on that.
If Lila, just real quick, there is a difference. Yes, if there is someone who builds a second-story addition, no one is seeking money. Presumably, the neighbors, the association, whoever says, "I want that second-story addition removed." Well, even under again the general law, the 25% cap wouldn't apply. But when specifically for collections work, when, oh, your dog was off the leash one day, we're going to fine you $100, and then we're going to charge you $15,000 in legal fees chasing that 100, which has happened, as you can read in Civil Beat, and that leads to $450,000 judgments, then there is a problem. And the problem is if you are asking for basically standard collection work, the condos should live, and it's not even the condos, it's the lawyers, should live with the same 25% cap as everybody else.
Well, for me, under the facade of legality, associations use association attorneys to quell inquiry, complaints, dissent. I think I sent to my coalition, which is about 1,000 people, that I learned a new word, lawfare. And that's what's being used against us. Just because we ask a question, do we really should we really have a cease and desist letter sent to us?
Yeah,
a boilerplate.
Yeah, and that's something that, again, I'd push back on some of Richard's comments on this, is that, yeah, we've had situations where people were asking questions, very basic things. They're sent cease and desist orders, charged thousands of dollars for them. And then other people are sent cease and desist orders almost identical to the other ones, also charged thousands of dollars. And the question of whether a judge would find those fair and reasonable or not is up for discussion. But I will say, in my mind, a document that costs thousands of dollars that's nearly identical to a document that was already done, that's not reasonable.
Well, my short view on this is a difference between attorney fees for collection of a debt, such as a delinquency and or a fine. It's very easy to move the fine process and the complaints and adjudication of the fine process by changing the statute to put it in the small claims court, and therefore you do away with all these legal fees, and attorney people don't have to. So it's easy to address that issue. The problem I have is I have another project where the owner in a high-rise condominium decided he'd like the more open space, so he tore out a load-bearing wall without approval and without a building permit. So meanwhile, the association says you have to put it back. And the person said, no, I'm not going to put it back. So they had to get a lawyer. And in that process, they filed bankruptcy, and they took all sorts of other defensive action to prevent things from happening.
Setting aside the question of cases like that versus situations where you're talking about a debt collector, would you agree with Lila and Terry, I think by implication, that sometimes associations abuse the process and use lawyers and this billing structure to harass owners?
Well, I don't know if harassing owners would be the word I would use. I would say certainly I personally agree that money judgments, such as unpaid maintenance fees or unpaid fines, we should look at a different approach than how it's being done today.
So again, the question of this lawfare using, the question was harassing owners. does that not never happen, or does it happen? You're saying no, it doesn't happen.
No, I'm saying that it's an isolated situation. I know of bad groups of boards that have done actions that I think were not correct, and I've represented the owners in individual matters on that. But to say it's a broad spread that every condominium in Hawaii, that every issue that comes up falls in the same bucket is not true, because
Well, no, we're not suggesting that.
because there's owners who also don't follow the rules and the laws and make it difficult for boards to enforce their rules.
Yes, for sure. Okay, so maybe we should move on to another question. But for the sake of perspective for everybody, my view on it is this. And again, to address this idea that we're trying to make all boards look bad by doing negative reporting when things bad happen. My thought is there are 1,800 roughly condo associations. I think that's the number. And even if, let's say, 1 in 10 has a problem, 1 in 10 is bad, 10% or 5% is bad, you're still talking about 100 to 200 associations where people are living in situations where things are really bad. They're living under governments that are really bad. So yes, it's true. We aren't trying to suggest that all associations are bad, but for us, when there are potentially 100 to 200 of these associations with tens, dozens, hundreds of people living in them, it's a problem. And then when we run into the answer, oh, well, they should vote the bums out. And then we run into a situation where we hear, wait, we can't vote them out. We're doing everything we can and they're blocking us. Then for us, it raises questions. And that's why we do the work that we do. That said, another question, again, trying to find common ground here. You guys, anyway, the insurance costs, big issue. Can anybody predict what we're going to be looking at if they're going to continue to increase for the next, 5 years? Are we going to see the same increases over the next 5 years that we've seen over the last few years? Jane, what do you think?
Well, that's a very tough question. And the problem is there are lots of factors that affect the cost of insurance that don't result from conduct of condominiums here. Insurance companies determine their rates based on a condo collapse in Florida, tornadoes in Nebraska, earthquakes in California, right? And so your insurance premium depends on what's happening in the rest of the country that's being insured by these carriers. And so, and we may not have, disasters here, but if that company is insuring, if we're in the risk pool with California and Nevada, where all these other things are happening, the insurance is going to go up. And right now, I think it is going to go up. And, people should be concerned, too, about claims. I mean, this is why it's important for homeowners to work with their boards of directors and boards to work with their owners. Because if you start having claims made against your building, guess what? Your insurance rates go up.
Yeah.
You start and because the association has to report these things. So if you start grumbling, rather than trying to work things out with your board and start filing complaints, your insurance is going to go up.
Richard, let's go in line. Richard, what do you think? What are you hearing out there?
Well, my biggest worry, to be honest with you, is the cost of owning a condo today. We look at just normal inflation at the cost of a loaf of bread. Then you start looking at the fact, what I'm going to call the insurance crisis we're in today, which are greatly influenced not just by the type of construction you have, but by your own claim history as far as water claims. As you may know, all property insurance includes water claims. So those buildings who have done a good job on their pipes and everything else are seeing much greater increases than the others. And then you get what I call legislative mandates. You may remember in last year's legislature, there was a proposal to mandate that every condo have earthquake insurance. We know earthquake insurance is average is about $400 a unit. It's the most expensive insurance, higher than flood insurance. So if the legislature passed these mandates without much thought that, well, the condo will pay for it, well, you're the condo. It's you who are paying for it. So let's get off these legislative mandates and start looking for solutions within our existing system that are affordable, that we can address the problems that have been identified by Stewart here. So, and the final thing is reserves. I would tell you now that I deal a lot with reserves. And most associations, when they have someone not paying their maintenance fees, what doesn't get paid? The reserve contribution. What happens when they look at the cost of having to fix the roof or the plumbing or whatever? I know one project, the proposed cost is $16 million. And they have to put that on top of the inflation, on top of the insurance. How do they afford that? If we don't start looking more objectively of how to run a condominium efficiently,
Yeah.
we're
Terry,
gonna
sorry
have
to interrupt. Yeah, thanks, Richard.
Yeah,
That's a great answer. And I'm going to circle back to some of these things.
So the insurance thing is a complicated issue. The reason rates are going up is because they can. Insurance companies make more money when they charge more. So that is a big factor. It's just like with tort reform. Oh, it's these awful medical malpractice attorneys. That's why we have to raise it. And then they did a study, and it's like, no, the insurance companies were betting a lot in the stock market in 2008. And lost a bunch of money, so the answer was tort reform. So a lot of this stuff, you think you're having one issue, it's really another issue that's going on. Another thing which is just true is before the Maui fires, State Farm looked at the state of Hawaii, and big insurance companies are not climate change deniers. They're like, yeah, we're not going to insure wooden structures in Hawaii, period, full stop.
Yeah.
So,
Lila, I'm sorry to interrupt, but Lila, what do you think? What are you
Sure.
seeing? What are you hearing? I know you know a lot of, you've told me about this a while ago, actually.
Right. I was a lender. I worked for a bank when Iniki hit. And the insurance effects of Iniki lasted 3 or 4 years. And so I expect that to happen again. Rather than complaining about insurance and insurance costs, I urge condo owners and their boards to harden their properties. Rather than spending the money on insurance, do the repairs that are necessary. You know, deferred maintenance costs us. Okay, and we've seen it. And I'm disappointed that the opponents of my coalition fought against us when we were talking about deferred maintenance. Lourdes is sitting over there. She championed the legislature to address deferred maintenance.
Okay, quick question. We're running out of time, and I really want to get to some of these other questions, so I'm sorry to interrupt you guys, but I am going to push us along here. What does an owner do when the board reveals they've done something like hired an unlicensed contractor who botched jobs, or the board failed to act on some kind of repairs? What recourse do the owners have, and are the systems adequate for that? So let's try to keep a quick question. First, are the systems adequate to what do they do? Lila?
Okay, of course, for unlicensed vendors, contractors, there's RICO. However, the problem is the boards.
Yeah.
The boards have to be educated, and they have to be held accountable for what they did, because they expended our monies on repair work that maybe have not been up to par, wasted our money.
Terry, aside from calling you, what do they do?
Besides that, you can call your fellow owners, raise it publicly in the board meetings, document what the concern is, would be a short answer.
Yeah. Richard, what do you think?
well, I don't condone anybody using unlicensed contractors with respect to making repairs. The issue is broader to me than that, because nobody wants to pay more maintenance fees. And I look at the associations that have been publicly brought out in Civil Beat and other organizations where they've had these multi-million-dollar assessments. Well, if you look at those maintenance fees of those projects against other similar projects, they were $200 a month per unit less. So why wouldn't you think over 10 or 15 years you didn't collect enough money to do the pipe repair? So the self-governance has its risk. And that's when they passed Act 199 last year, which required more mandated disclosure requirements, reserves. it was my hope that that would get the attention of the insurers, the government, the buyers, the existing owners to take more definitive action on their reserves.
What do you
Because
think?
we certainly, not in all cases, but in many cases, we have deficient reserve contributions and funding
Okay,
to
Jane,
deal with it.
sorry to interrupt, Richard. We got to get through this.
I agree with most of the panel members that, number one, unlicensed contractors are a no-no.
Yeah.
And, I think and when we do our education through Hawaii Council seminars, we, harp on the fact that, you have a fiduciary duty. You have to go out and get licensed contractors and make sure that the people that you hire to do the work on your building are, qualified to do the repairs. Because otherwise, if you don't do that, you're only facing more money in correcting the deficiencies that occur if you hire unlicensed contractors or people who are not qualified.
Yeah. Well, another question. Somebody had a question that was more specific, but I want to ask a broader question. Harassing. We hear about people harassing each other. You have maybe sometimes a board person or a owner harassing a vendor, or the board harassing an owner or another board member. How do we get past that so that just doesn't happen?
I don't have an answer to that because, we get it in a second hand. We usually get it from the contractors.
Right.
Who say, you have an owner who comes down and tells us how to do our job.
Yeah. Richard, what do you think? Quick question. Is there a way to pass this?
Definitely an issue, but it goes both ways. You have board members who get angry and they want to take some kind of action against the owner. You get owners who don't want to listen to the board and they take actions against the board members. Then it goes with the tenants as well. It's not an easy thing to do and to resolve, to be candid with you. It's human nature in a way, and strengthening our laws on retaliation things are helpful, but it's not going to solve the problem.
Terry?
Yeah, it's not a one size fits all because there are people that are just mean and bullies, and there's people that aren't bullies but are have serious mental health issues or drug issues, and you don't know what might solve an issue for one person might not solve an issue for another. There is 514B 191, which is the anti-retaliation statute, and trying to figure out what is this person's glitch might be helpful.
Lila?
Harassment exists. Like I said, I have about 100 email addresses that I write to, and I didn't advertise, I didn't request, I don't have a website. These are people who reached out to me, and I have a list of over 300 associations that people willingly named to say we have problems in our association. And a lot of the problems are harassment over really manini issues.
I'm sorry, how many was that again you mentioned?
Over 300 associations.
So this is kind of the number I was throwing out there. That's not at all, we're not saying that's all 1,800 associations, but that's a lot. So I really want to thank everybody. We have to cut it off for now, but I want to thank everybody for coming. Also, I want to point out, I have business cards over by the Malasadas. So if you want to grab a malasada, you can also get my business card. Feel free to call me. The best way, I think, would be to text me and then call. That's going to be the best. If you call, I might not answer. If you email, it might take me a while to get to it. But if you text and then call, that's a great way. Thank you again, Jane. I really appreciate it. And I'm happy to see that there's a lot of common ground among this group. However, it's not as common as you guys were suggesting at the beginning.
Thank you for hosting us.
Yeah.
Appreciate it.
Richard, thank you.
And my encouragement.